After January 2025 fires, Governor Newsom issued an executive order that made it illegal to make unsolicited offers to owners of real properties located in certain impacted zip codes. There are 15 zip codes here, and those are the fire affected areas. Okay. Unsolicited offer means any offers to purchase by any person, by text, email, telephone, mail, or other means of communication. Trying to buy the property under market value, saying, here's my offer, direct, and all that. One thing that you need to know that the uh, anytime that you have an agreement or a sale, whether it's a vacant land or a single family home that is in this zip code, you want to make sure that the escrow officer knows about this form and has the form recorded with the grant deed. Okay. So basically, the form says that the seller agrees and both buyer and seller sign this form saying that the offer that was made was not unsolicited. So if there is a sign in front of the property, if there is the property is in the MLS, whatever, then you're all okay to approach and sell the property. But and again, make sure that this form is recorded. If it's an unsolicited offer, the seller has 4 months of cancellation right, even if your escrow is closed. So be careful of that. This is really important. Just remember these 15 zip codes. This is valid to, or this is in force until January of 2027. Okay, so hopefully by that time this form will go away. The next form, and if you have any questions, whatever, raise your hand, virtual hand, or just unmute yourself and I'll be happy to answer questions. The next form is the referral fee agreement that has been updated. Okay. And you have this box at the bottom where the agents, the referring agent and also the representing agents can initial. And once you use the referral form, you need to use a new updated RAD. That's a realtor acknowledgement disclosure. We had the realtor acknowledgement disclosure in the past, but it only talked about whether you're a realtor or not. But now the new one has been completely updated. Okay, so this is the realtor acknowledgement disclosure. The first paragraph distinguishes between realtor from other licensees. And the question could be who's other licensees that could have access to these forms, could be attorneys, could be people that are buying the forms from C.A.R. direct. Okay. The part 2 or paragraph 2 clarifies escalating steps a principal can take if not satisfied with their agent. And it basically says, look, if you're not satisfied with your agent services, talk to your agent and call the broker of the office. If you are not happy with the results, whatever, you may contact the local association. Our local association will hear the complaints and try to make sure that they direct them to the right process and all that. So it's really good information here. Sometimes it could avoid an unnecessary lawsuit or other claims. Paragraph 3A is an optional paragraph that discloses if broker is receiving compensation from multiple sources. We have buyer broker agreement that let's say at an X dollar amount, and the seller says, I will pay you Y dollar amount, and Y dollar amount is lower than the X dollar amount. So the seller is paying the Y dollar amount, the buyer is paying the difference. This is the form to use and say that, hey, I'm getting funds from different sources, or if you're getting money from brokers or whatever, different sources. Paragraph 3B, it's a present or potential ownership. And this has become an issue in a lot of cases where the agent fails to disclose that they have any interest. They may have an interest in an LLC or whatever, and they think that, well, it's an LLC. I don't have to disclose. No, you have to disclose. Okay. So, um, it's present or potential ownership contemplating a purchase or a lease of a property for myself, a member of my immediate family, an entity for which I or my immediate family member have a legal interest, like in your LLC, any other person related by blood or marriage. And the last one is the sticky one that says any other person with whom I have a special relationship. Could it be a girlfriend? Could it be a boyfriend? Whatever it is, needs to be disclosed, needs to be disclosed. And the last portion of it, 3C, is an optional paragraph that it discloses if the broker is paying or receiving a compensation. Now it has to be disclosed. We have gone through this transparency of compensation coming into the real estate companies, and who pays the compensation and all that big lawsuit and everything else. Now the C.A.R. is ahead of the game because they don't want another lawsuit to come up for the referral. That maybe the person was not aware that their agent that is referring them to someone else is receiving a referral fee, receiving compensation. Okay, so anytime you do a referral, you need to use this form, and you need to make it clear to the person that you're referring to, that you're referring that person to another company or whatever, that you are receiving compensation. And the person that receives that referral has got to report again to the person that, hey, I am paying a referral fee. I am paying a referral fee. That has been also up there. Residential listing agreement has been updated where it says broker is paying a referral fee. So if you are getting a referral and you're paying a referral fee, you have to check this box and attach the form RAD. Also, the listing agreement has been updated with the digitally altered images, which I think Sevak is going to go through it a little bit later on. On the buyer representation agreement, again, if you are paying a referral fee, you must check this box and attach the form RAD, and also let the person know that you are paying a referral fee. On PSRA, the same thing, property showing. On the lease listing agreement, again, the same thing. It has to be disclosed to both parties. So that's as far as the referral agreement is concerned and the form RAD is concerned. Now, on seller property questionnaire, questions were added to disclose if seller is aware of any gas-powered appliances or any laws that is going to be in effect. City of Glendale was thinking about making it mandatory to change from gas, all the homes from gas to electric. And if you're aware of something like that, if the seller is aware of something like that, not you, if the seller is aware of a rule like that or anything that is coming up, then they have to disclose. Also, any residue which may be indicated by a smell or taste. This is the third-hand smoke law. We had the smoke law, we had the second-hand smoke, now we have the third-hand smoke law. Okay, so if the seller is aware that any occupant of the property had smoked or they had smoked in the past or whatever, then they should answer this question and they should clarify whether they're aware of those residues or not. This could be an issue a few years down the line, or we don't know how this is going to go. But just like mold, there's an inspection for mold, and if the seller is aware that there's moisture or mold or whatever, they should disclose, and the buyer has the right to do an inspection. The buyer could do an inspection of the carpets and take samples of the carpet. The buyer could take samples of drywall or whatever and check for residue of nicotine or anything, any smell or anything. Okay. The stove and refrigerator. Okay, this is on residential lease or month-to-month rental agreement. Stove and refrigerator law. As of January 1st, 2026, as of January 1st, 2026, all rental properties must have a working refrigerator. Okay, now, if you currently have a tenant and the tenant has their own refrigerator, and the tenant says, you know what, I don't want to use my refrigerator, or my refrigerator just went bad. The tenant can give a notice to the landlord, and the landlord has to provide a refrigerator within 30 days. Okay? Now, the refrigerator does not have to be new. The law doesn't say whether it has to have a freezer, but if you're going to get a refrigerator, you might as well get one with a freezer and get it over with. Now, if you're leasing a place out today and the tenant says, I have my own refrigerator, I don't need it, okay? Then you want to check this box that the tenant elects and housing provider agrees that there shall not provide a refrigerator. The tenant's refrigerator, the maintenance of it is responsibility of the tenant. The refrigerator that the landlord provides, just like the stove, is the responsibility of the landlord. Okay. The forms, the other forms that have been updated with that law are residential lease after sale, change in terms of tenancy. It's got the same thing in there. The residential lease after sale, the box is already checked because the seller is already occupying it. If it's 30 days or longer, the seller becomes the tenant, the buyer becomes the landlord, right? In the RLAS. So this box is already checked. So the seller already has their own refrigerator. Notice of change in terms of tenancy, the stove and refrigerator law applies. And then also the extension of lease, the same thing. So if you're extending a lease, they're currently in a lease agreement and you're extending the lease, you have to provide that opportunity for the tenant to say, I'm going to keep my refrigerator, or I will provide you with a new refrigerator. Okay. Questions so far? Because I want to change the page. I want to go to another page.
Rick, I have a question.
Sure.
Let's say the tenant has provided their own refrigerator and then it breaks down. So can they come and ask the landlord to provide them with the same kind of refrigerator? Maybe it has a lot of bells and whistles that's expensive. What is the responsibility of landlord at that point?
Great question. The landlord will provide a working refrigerator that is not on recall. It does not have to be brand new. It can be used, okay? But as long as you have a refrigerator, and the law doesn't say that it has to have a freezer, but I would, if I was the landlord, I would have a refrigerator with a freezer, and I would provide that. It does not have to be exactly the same model as what the tenant has in.
Thank you.
Oh, I saw Susan raising her hand, but now it's down. Susan, do you still have a question or you're satisfied? Okay.
All right, let me go to solar. That's just another form that we need to has been updated. There are a lot of other forms have been updated, but they're all minor changes here and there. Um, and the solar has been updated. Solar is becoming a major issue with claims because a lot of people are not disclosing what kind of, or a lot of sellers don't know what kind of a lease they have. They don't have the documents, and solar companies are usually taking their time responding. So the first page of the solar advisory is just an advisory, okay, and which is important to both buyer and seller. Part two, okay, is the instruction on how to fill out the form. Okay, part three is the questionnaire. Okay, which separates paragraphs that are more directed to owned, leased, or power purchase agreements. And if there are multiple solar panels or multiple solar units on the property, you know, some people may have gotten some solar panel a few years ago. Now they added some more. So now they have two separate systems. Okay. So they have to fill out um, separate forms, so separate solar advisories for each separate system. So if the property has multiple solar power, use separate solar questionnaire for each um, system. Uh, if uh, are you aware if the solar is owned, leased, or other? It could be power purchase. Okay. Um, if the solar panel power is system is owned and conveying with the property that the solar panel is going with the property, then the seller will answer all these questions, whether there's a balance or whatever. It would be good if you're the listing agent and you're getting the listing, there's solar on the building. You want to make sure that you ask the seller to please pull out all the information, get all pertinent information, give it to an escrow company that you're going to work with, and ask the escrow company to send a demand, send some information, get something. We had one just a couple of weeks ago that there was less than $15,000 left on the balance, and the buyer was an investor, and the solar company said, "We will not allow the investor to take over that loan. It has to assume that loan. It has to be paid off." So buyer and seller agreed, and they have they're going to pay off uh, the solar panel at close of escrow. If the solar panel is subject to a lease or a power purchase agreement, a lease, you're leasing it, and at the end it's yours. On a power purchase agreement, okay, you're paying a monthly payment to purchase that power. And at the end, the solar company has the right to come and pick up their equipment and take it with them. So that these are the most important forms that have been updated. So if there's any questions, please raise your hand, unmute yourself, and I'll be happy to answer your questions.
Rick, Susan Brazilian was having an issue, a technical issue on muting. So she posted her question in the chat. She asks, I understand that the refrigerator provided by the landlord must be used inside the kitchen, not the garage or outside. It has to be used as their main fridge. Is that correct?
Yes, yes, that's correct. Very good, you know, addition. Yeah, yeah, that's correct.
Thank you. I believe Carmen had raised her hand. Carmen, you have a question?
Yes, about solar. I've had an occasion where my buyers were looking to buy a house that had solar panels. However, the owner had one contract for panels both on the house that they were selling and their own personal residence. So it was a big mess in terms of determining, you know, the type of agreement and all the necessary information that goes along with that. Any discussion about that? Any thoughts about situations like that, Brick, that you're aware of?
Nothing like that came up at Standard Forms Committee. I think if something like that is going on, the best thing to do is probably um, talk to the solar company and possibly pay it off partially on the buyer side, partially on the seller side. I don't know. It's a negotiation thing, but that I've never heard of a solar company putting one system on two separate homes. Um, or
It wasn't one system, it was two systems, but one contract.
yeah, maybe the solar company can separate those panels out and then give the new buyer free and clear solar or something like that. But I think it would be negotiable with the solar company,
Very good.
between buyer, seller, and solar company. It's a mess. That's a mess. Solar systems right now, honestly, are a mess. There are a lot of solar companies that have installed the solar panels and they've gone bankrupt, nowhere to be found. And we need to locate who's got the lien, who's got the loan, who's got the all of that in order for them to be able to negotiate something. So that's why you need to start as soon as possible. As soon as you get the listing, start the process on solar panels.
Good point. Thank you.
Any
Any other
other
questions?
questions? Oh,
Hearing none, I'm a member of Standard Form Advisory Committee, as Sevak mentioned. If you have any problems with any of the forms, if you have any suggestions, if you want to see new forms, I don't think anybody wants to see a new form, but if you want to see new forms, if you um, have any suggestions, whatever, feel free to get in touch with me or send your suggestions to Sevak, and I will be happy to take it to the Standard Forms Committee meeting. These forms also are available. Whatever that I did, the presentation here is available, and our association has it. And if you need it, please contact Sevak, and he will be able to forward it to you. Thank you very much for the opportunity, sir, and that ends my report.
thank you for your time. Okay. Everyone should be seeing my presentation slide on your screen, and we are going to be continuing our today's topics. The first topic that we're going to go over has to do with rules regarding altered media. First, let's make sure that everyone understands when there's a hierarchy of rules and regulations, obviously. This is one that obviously there has been a legislation passed on it. So when a legislation is passed on a practice rule, then it trickles down to C.A.R. and then so forth, so on. So this is the California law regarding altered media. Effective January 1st of this year, California's AB 723 requires real estate brokers and agents to disclose if listing photos are digitally altered or use AI to modify, add, or remove elements of the real property features like walls, furniture, views, etc. These altered images must have a conspicuous disclosure and a link, or immediate access for that matter, to the original unaltered photos. And this regulation is very straightforward, and I believe everyone understands exactly what the requirements are. Keep in mind that this regulation applies to also photos used in flyers or advertising, whether digital or print. So if you have a property flyer for your open house that has a digitally enhanced photo, it has to follow this regulation. All right. It is not simply for MLS or online purposes. Even print advertising will require for you to comply with this regulation. Now, you might think about how does a flyer provide access to the consumer for the original unaltered photos? Well, If there is a website that you can include the link or a QR code on your flyer that takes the consumer from your flyer to that site, you will be in compliance. That's one way of handling it. Now, in regards to the altered media, CRMLS rules, like the state law, digitally altered image means same. An image or photo altered or use AI to modify, add, or remove elements of the real property features like walls, furniture, etc. However, it emphasizes a real property feature as a key component of this CRMLS rule. Digitally altered elements in a photo that are not the real properties feature are simply not allowed. For example, a utility pole in your photo. You cannot Photoshop it out. Neighbor's property being visible in the photo that, oh, it is right there in my backyard. There is lack of privacy in my backyard. I'm going to modify it. I'm going to eliminate that. You cannot do that. Those are not your real properties features. There are other properties, other owners' features, so you cannot do that at all. While minor photo exposure and other photographic adjustments are allowed and not considered digitally altered, overdoing such adjustments like lighting up a room to a point that suggests ample natural light in that room would be considered a digital alteration. And it will require disclosure and access to the actual photo. Is there a penalty assessed? Not currently. CRMLS's Rules Committee will be meeting later on in the year to establish applicable penalties. Now, what are the rules regarding MLS input of altered media? A subscriber who submits to the MLS any digitally altered image must also, 1, submit the original unaltered version of the same image. 2, ensure the original unaltered version is displayed in the listing immediately before or after the digitally altered image. And 3, ensure that the digitally altered image is labeled as photo modified, virtually staged, digitally altered, or AI altered, or some accurate, substantially similar term in the text field section for the altered photo in the add or edit module. Once again, I would appreciate if you can mute your audio so that there will be no distortion. Thank you. Now, please pay attention to item number 2 specifically. It says, ensure that the original unaltered version is displayed in the listing immediately before or after the digitally altered image. That means that you are not going to put in all the digitally changed, altered photos first together as a group, and then put a whole bunch of photos that are the real photos towards the end of it. Each one of those altered photos has to have the real photo either before it or after it. So make sure that the order of your media photos in the MLS is correct. This is important to remember that CRMLS currently allows 75 photos per listing to be uploaded. And that is relatively an adequate number of photos for most users. However, if you're submitting a large number of digitally altered listing photos, for each one of those, you must also upload an unaltered photo which will go against the count of 75 allowed. So be mindful of that. And last but not least, be mindful if you are inputting a listing in an MLS system other than CRMLS, those systems will most likely have similar requirements as well with input guidelines and limitations. So be mindful of those. Now let's talk about the rules regarding removal of media. I don't know if you guys have directly been approached by a potential new owner of a property asking you to remove photos of the property off of the MLS and what have you. This is something that we here, the staff of Glendale Association of Realtors, we do receive calls, at least maybe 1 or 2 per week. So this is important for you to understand as to what the regulations are and how CRMLS is going about assisting us in handling the situation. So first, let's go to the legislation. There is a Civil Code 1088 specifically discussing this, saying that a multiple listing service shall retain and make accessible on its computer system, if any, all listing and other information placed in the multiple listing service by an agent or appraiser for no less than 3 years from the date the listing was placed in the multiple listing service. So the regulation requires it, quite simply, all right? We are following the regulation. The MLS is following this regulation. There are exceptions, of course. Court orders, law enforcement agencies' requests, or other potential legal concerns are exceptions that will be reviewed by CRMLS, and it might be permitted for removal of certain photos from the MLS. But these are very rare and require legal backup for that request. Now, let me tell you about how this is going to go with our CRMLS in reference to MLS use when it comes to removing media. What is CRMLS rules talking about when it comes to this topic? Listing agents, this is a CRMLS rule. Listing agents may remove any media, photograph, video, drawings, etc., from their listings, leaving only one exterior main photo prior to the listing changing status to active, under contract, or pending. Once the listing has changed status to active, under contract, or pending, this reflects that there has been a transaction that's been initiated and it is in process. Once there is an accepted offer and the listing status effectively declares that a sale has taken place and is in process, any uploaded media is considered as historic data in relation to that sale, and it will no longer be removed from the MLS. Because those historic pieces of information, so-called historic data, are references as to under what conditions the sale is taking place. And I'm pretty sure that most of us, if not all of us as practitioners in real estate, would love to have access to these photos through MLS so that we'll be more accurate in our comps, in our processes and analysis. So this is the regulation. I once again ask kindly to mute your audio. Thank you. All right. Now, how is that going to be handled? How is removal of media from MLS going to be handled when it comes to third-party websites? Okay. This is to let you know that CRMLS has updated its licensing agreement. which simply does not allow third-party websites using IDX data share technology to display any media other than the main exterior photo for listings that are off-market. When they are sold, they are expired, they're canceled, they are no longer available for sale, there is no ongoing sale transaction, it is off-market. The licensing agreement that CRMLS has updated for IDX users simply prevents them from showing it. Once a property is off-market, visitors to those third-party websites receiving their data shared through IDX technology cannot see property photos other than the main exterior photo, period. Now, this applies to all CRMLS listings and not only to new listings as of now. So anything that was sold 3 years ago and it's in CRMLS, those third-party websites using IDX technology will not be able to show any other photos but the main exterior photo. To clarify the data share technologies and the differences that exist, as you might know, or there are two technologies out there for data share. One is the IDX that CRMLS rules that I just described applies to IDX technology. The other one is VOW data shares. These are virtual office websites. Establishing a virtual office website is a very, it's relatively a very expensive proposition. Not many practitioners or brokerages go through a VOW data share. I asked a question from CRMLS Vice President of Technology as the number of VOW clients that CRMLS has. And considering that CRMLS provides services across the country, it's not just Southern California or Northern California, it was amazing to hear that overall they have only about 30 VOW data share clients. Who uses VOW? Sites like Zillow,
Redfin.
Right, Redfin, Berkshire Hathaway has a VOW site, and many others of the large size brokerages. So those are not yet included in this regulations, in this licensing agreement, and CRMLS is looking into the legal aspects of the applicability of this IDX related licensing rule for VOW platforms as well as we speak. Just to give you a little bit of an update in regards to the big elephant, or one of the big elephants in the room when it comes to VOW, Zillow. The relationship between Zillow and CRMLS is a very good, close relationship. And Zillow has accepted CRMLS's regulation licensing requirement that is in place for IDXs to apply to its VOW platform. So Zillow will no longer show photos of listings that are off market once the status changes to sold or what have you. So Zillow, despite the fact that they are a VOW data share, they will follow the CRMLS's IDX rules and licensing agreement. Okay, those are a couple of things that were quite important for us to share, and I see Carmen has a question. Carmen?
Yeah, you said that Zillow has a good relationship with CRMLS. What about Realtor.com or Redfin? What about them? Do they also have the same understanding and agreement or no?
Redfin doesn't. Okay, Redfin is not in the same category of, or we, let's put it this way. At least CRMLS had not heard otherwise from anyone else. I would suspect, and this is just an assumption, I apologize, but I would believe that Realtor.com will also follow suit.
Makes sense. You mentioned specifically Berkshire Hathaway. What about other big ones like Coldwell Banker and so forth, where
Um,
they're the recipients of these photos?
I
What about
don't
them?
have a complete list of all the VOW clients. They mentioned it was a verbal communication with the CRMLS technology folks. And I just put down on the paper names that I remembered, but I don't know about Coldwell Banker. The parent company of Coldwell Banker, I believe they have a VOW as well. And so right now, we're talking about only Zillow and possibly Realtor.com, who have VOW data shares, but they will follow this new licensing requirement from CRMLS for the IDX data share.
Thank you.
All right. Okay. Now let's talk about DRE's enforcement issues. While we were in Monterey attending C.A.R.'s winter meetings, we had the opportunity to hear directly from the DRE's commissioner. A couple of things that were of importance I would like to share with you. Number one, when it comes to the form BRBC, DRE reserves discretion for interpreting BRBC's requirement to get buyer signature as early as possible. What does that mean exactly? Although that's the regulation, that has the words as early as possible, and it follows prior to writing an offer. However, DRE commissioner expressed that there should be no reason for a BRBC not be signed prior to showing. So although BRBC not being signed prior to showing still might be fitting in the current regulation, but they are reserving discretion to pass a final judgment if and when a case arises that there was something that was not compliant, and they further find that the reason that a BRBC was not signed prior to showing was just an excuse or not acceptable, that would be also added to the pile of complaint issues on that specific situation. So keep in mind that although it says BRBC should be signed by a buyer as early as possible prior to writing an offer, but they are actually expecting, if there are no good reasons whatsoever for it not to be signed prior to showing, for BRBCs to be signed prior to showing. Keep that in mind. Also, the DRE commissioner asked the realtors to continue on the tradition of cooperating with DRE on reporting non-compliant activities. As you should know, as far as the history of realtors are concerned, our organization was formed long before there were any laws, any regulations in the books talking about specific real estate transactions. Our trade association was ahead of legislation over 100 some years ago. And we have been self-policing, a self-policing industry. And the DRE commissioner strongly recommended for us to continue that practice, because it is through us that we can withhold higher standards throughout. I must tell you, as Glendale Association staff members here, we do receive notifications from our members, and we do appreciate your participation in this Self-Policing Act. This is really important, as it was brought up by the DRE commissioner as well. All right. Let me give you a couple of updates on legislative issues, things that have popped on our radar in the last 2 weeks or so. I'll begin with something that was on our radar at the end of January. And when we were in Monterey on the meetings, we heard about this, that although C.A.R. had opposed a proposed bill, it was Assembly Bill AB 1406. AB 1406 passed the Assembly with narrow margin. For those of you who might not know what AB 1406 was talking about, this is a legislation that is addressing liquidated damages for brand new condominium development to go up from 3% liquidated damages to 10%. Now, what I just said, 3% to 10%, was the initial version of this legislation. They heard a lot of noise from realtors and others. They altered it. They adjusted it down from 10% down to 6%, which is still double what we are familiar with. And that legislation in the Assembly passed by a narrow margin. It is on its way to California Senate, and we are hoping that we'll be able to stop it in the Senate. When time comes to act and notify your legislators on your opposition to this, we will notify you through our red alert emails and what have you, and we would appreciate you taking part vigilantly. The other issue that I'd like to talk to you is something that is being heard as we speak right now. LA County is considering a regulation based on some very flawed structure to regulate the eviction process. As you know, in LA County, the Board of Supervisors has practically routinely, after the fires, passed special regulations under the Emergency Act by structuring eviction processes, rent increases, anything and practically everything that has to do with a rental transaction, putting it on emergency basis, calling it because of this, because of that, fires or what have you. Our residents in LA County are at times negatively affected. They are unable to handle their rents, so therefore landlords are going to be bearing the financial difficulties. So the current version of what's going on is, and as I mentioned, it's being heard right now, has to do with a regulation that it says an eviction process due to non-payment of rent, should only get to be initiated by the landlord when and only when the balance that is not paid, the accumulated balance unpaid, is 3 times a fair market rent value of that property. Now, this is something to notice. Number one, a fair market value per HUD will be the basis of this, number one. Number two, the actual rents in LA County, oftentimes you as agents come across very often, and you are very well familiar with it. The actual rents are oftentimes way below the fair market rate, thanks to other rent control measures and what have you. It is not unrealistic to come across units that are rented at $1,000 a month when the fair market value is twice that. It's $2,000, even according to the HUD own table of fair market rates. So when you are looking at what is being considered, that the unpaid balance of the rent should be equal to 3 times the fair market rate. If the rent that is being paid is only 50% of the fair market rate, it is going to take 6 months in this example for the accumulated unpaid rent to reach the 3 times of that $2,000 in this example that I was giving you. The actual rent is $1,000. The fair market rate is $2,000. The accumulated balance should reach 3 times the fair market rate. That is $6,000 before the landlord can start eviction process. For someone who's paying only $1,000 on this, this will take them 6 months. The other concern is this. What if that tenant intermittently starts paying a little chunk of money here, a little chunk of money there, and somehow keeping that unpaid balance below 3 times market fair rate? The 6 months can become 9 months, who knows, a year. So this is totally upside down. And it is an overreach, not only into the pockets of mom and pop property owners, housing providers, but there's also a different legal aspect to this as well. There is a possibility that they may stretch this to override anything that 88 chartered cities within the jurisdiction of LA County currently have on their books in their own regulations. Typically, LA County deals with the unincorporated parts of the county. Like we have in Glendale, there are parts of Montrose, La Crescenta. We know that they are part of the unincorporated part of county, so those will be subject to a regulation like this if it passes. But then what comes next is arguing through attorneys and what have you, and possible lawsuits between chartered cities and LA County as to, well, what do you mean this is county-wide? We are chartered cities and we have our own regulations. So as we speak, LA County supervisors are having their conversations on this issue. Carmen?
Yeah, just one note that if you get a real estate attorney involved in the eviction process, the first advice would be that any monies offered to you by the client, do not accept it, because they will use that to just prolong the process. So that's where people should take notice. Just a comment.
Thank you. There are definitely concerns because things of this nature have a lot of loopholes and allow things to just drag on for much longer, during which time the housing providers are bearing the financial cost of paying a mortgage, property tax, insurance, maintenance, and all that stuff while not collecting any rent. And then they will come back to us as housing providers and say, oh, how come you're not fixing this and fixing that? Because you didn't leave us any money to operate this business correctly. Anyways, all right. Wanted to thank you guys for participating. I hope that you found the information that we shared with you of value. If there are any questions, by all means. If not, once again, Mr. Vonyadi, thank you so much for your participation and sharing the information on the forms. Thanks to 100 plus registered individuals who unfortunately